Yes, good evening. Welcome to another daily dose of Satoshi's News. Today's date is Monday, the 16th of October, 2023, the year of BSV. Buy BSV.live, the best place to buy Bitcoin SV online, the original protocol and genuine Bitcoin. Here we go. Let's get into this. Thanks to Nom for bringing this to my attention straight away. Absolutely on the ball. He's been absolutely amazing. So let's go through this. So it sounds interesting. Just 3 hours ago, Jordan Atkin writes, Court rejects COPA's disingenuous document requests for Satoshi identity trial. All right, let's see what they're after then. So Dr. Craig Wright squared off in court against the Crypto Open Patent Alliance in September over a number of applications made by both sides, ending with a ruling last week which saw the court slap down COPA's most significant requests, including that they be allowed to rely on 2 expert reports on document authenticity served in earlier cases. Before Justice Miller, Dr. Wright had asked the court to exclude certain hearsay evidence that COPA was seeking to use at trial. These were 2 reports, one provided in the Kleiman vs. Wright for Dr. Matthew Edman, and another produced in Granoff vs. Wright by KPMG, in addition to an expert report already by Mr. Patrick Madden arranged by COPA. Yeah, I mean, we heard KPMG go in and give their report. It was ridiculous. Totally, utter hearsay. Speculation. There was no facts. There was no factual evidence in what they said at all. Both reports examined a number of documents and emails that were submitted into evidence in those cases, and both concluded that some of the documents had been forged or otherwise altered. Both expert report did not express an opinion on who forged or altered the documents or why. Dr. Wright has consistently maintained that many of the documents in the record are forged or altered, often in ways designed to make Dr. Wright look bad. The court rejected the inclusion of both the Edman and the KPMG reports, remarking that as Dr. Wright submitted, the upshot of this is that COPA intends to rely at trial on expert evidence for no less than 3 experts in the same discipline, and that allowed COPA to do so would be wholly duplicative. COPA, well, this is in brackets here, COPA submitted that there would be no unfairness to Dr. Wright because this expert report would only need to address the documents considered by Mr. Madden. I found this submission disingenuous. If the Edman and KPMG reports remained in evidence, Dr. Wright's expert and legal team would have to consider them. The court also remarked on the practical difficulty of including the reports, highlighting that it would be impossible to tell whether the documents referred to in one report was really the same document referred to in another. This, said Justice Miller, would necessitate further expert reports. Yeah, and more experts and more experts and more experts. And we know how crap experts have been in these last few years and their opinions. Carry on quote here, I cannot understand how the judge trial, likely to be me, is going to benefit from having another 7 expert reports, whether the only relevant material is accepted to be entirely duplicative. COPA had also challenged Dr. Wright's ability to rely on expert evidence concerning his autism spectrum disorder diagnosis. The evidence comes from the renowned forensic psychiatrist Dr. Sina Fazal, Professor of Forensic Psychiatry and Director of the Centre for Suicide Research at Oxford. Justice Miller summarised the contentions made by Dr. Wright on the basis of Dr. Fazal's report as, and number 3 points here, Dr. Wright has ASD and is therefore a vulnerable person with a disability. Dr. Wright's ASD impacts his presentation in court. This means it will be important for the judge and other court users to be aware of this in order to ensure a fair trial. And given that Dr. Wright is a vulnerable person with a disability, the court will naturally wish to consider what reasonable judgments may be appropriate in order to accommodate his ASD. COPA challenged this on the basis that Dr. Wright had apparently been able to give testimony in prior cases, such as in McCormack and Granoff, despite his diagnosis. However, Justice Miller, noting the vigorous resistance by COPA, honed in on the obvious point that no accommodation for Dr. Wright's diagnosis had been made in either of those cases. COPA's reliance on what occurred in previous proceedings rather begs the question. In each set of proceedings, some strong views were expressed by each judge as to Dr. Wright's unreliability as a witness. One does not know whether the same view would have been expressed if some or more adjustments had been made. Justice Miller went on to say, in any event, autism is a spectrum, and those who suffer from ASD develop various coping mechanisms. These may well enable someone like Dr. Wright to appear to speak confidently in a public environment, especially with slides and prompts. He may also be able to cope with cross-examination on aspects of technology, which is very familiar. But cross-examination in this case is most likely to be so confined, bearing in mind that COPA challenges the authenticity of every one of the 107 principal reliance documents which Dr. Wright has identified. The court also ruled on a series of requests for further information by both sides. For instance, COPA asked the court to order Dr. Wright to provide more information on the precise ways that Dr. Wright's prior expertise on things such as incentive systems and digital currency informed his eventual invention of Bitcoin. The court rejects that, saying that the request gives the impression that it is simple to take each of the 5 and other concepts and plug them together to see how the white paper was devised. Whoever wrote the white paper had engaged in some novel thinking. It is often extremely difficult after the event for someone with an inventive frame of mind to pinpoint where all the ideas came from and which coal skidded. To give rise to the concrete description in a document like the white paper, he said. The court also rejects requests for further information on a project Dr. Wright had been involved in 2021 called Blacknet. Dr. Wright tweeted about Blacknet alongside applications to the I think that's the Oz industry and an extract from the Bitcoin white paper. Dr. Wright's degenerators jumped on this as though Dr. Wright was claiming that the white paper and the Blacknet were one and the same, but he never did, as Dr. Wright explained in argument before the court. This was his explanation. Dr. Wright first submitted his Project Blacknet research paper to the Australian industry in 2001 as part of an application for a research grant and research and development tax rebate. He obtained research and development tax rebates from the Australian industry, but not research grant funding, for Project Blacknet during the period 2001 to 2009. He subsequently and unsuccessfully sought research grant funding and research and development tax rates in 2009 and 2010. Dr. Wright updated his Project Blacknet research paper each year and he submitted it to the Australian industry. Early applications did not contain the abstracts of the white paper, but later unsuccessful applications did. The image of the research paper published on Twitter is that used for a later application containing an abstract of the white paper. The court accepted this reasoning and rejects COPA's requests. Justice Miller said that Dr. Wright does not appear to be asserting in his action that anything to do with the Project Blacknet directly proves he was or is Satoshi, only that it was an early contribution to the ideas which eventually became Bitcoin. COPA was not entirely without victory, however. Indeed, by the time the September hearings, Dr. Wright had already agreed to many of COPA's requests, including the rather onerous task of identifying for COPA all authentic drafts of the white paper in Dr. Wright's disclosure and to specify the date on which each and such document was created and state whether Dr. Wright is aware of any of those documents having since been altered, and if so, in what respects. The court also grants other COPA requests, such as for an explanation as to why Dr. Wright destroyed the hard drive containing the private keys for the information on the versions of the white paper that had been uploaded onto SSRN, the repository for scholarly papers known as the Social Science Research Network. Justice Miller's engineering background bodes well for Dr. Wright. Beyond the rulings themselves, there are some notable details revealed in the judgment. Interestingly, it appears that when the hearing was scheduled, the court forgot to let Dr. Wright's lawyers know. The judgment calls this regrettable and mentions that the result was that, for entirely understandable reasons, they were not in attendance. The hearing was held away and COPA made submissions on the request for information requests. The court invited Dr. Wright's lawyers to come to court at the earliest opportunity to make their own submissions, which took place a few days later. Secondly, taking the judgment as a whole, one gets the impression that Justice Miller is rather more amenable to Dr. Wright's claims than previous judges have been. For instance, Justice Miller acknowledges the importance and potential impact of Dr. Wright's ASD diagnosis, where previous judges have been less open and sometimes ignored it entirely. compared Justice Mellor's approach with Judge Reinhardt's reaction in the Kleiman to what he perceived to be evasiveness by Dr. Wright. He attempted to hit Dr. Wright with sanctions, including disallowing evidence that was at the core of Dr. Wright's case. That's outrageous. The sanctions were overturned by a higher judge, and Dr. Wright ultimately won the case. A similar sign can be seen in Dr. Wright's passing off cases against Coinbase, the Nasdaq coin, and Kraken, also currently being submitted or administered by Dr. Justice Mellor. So again, being administered, that's what it all comes down to. They're administration courts. Administration courts under... what's the case? Crikey, this is important because it's in London. So it's a Halsbury's Law. In fact, while we're on the case there, we'll just go to Halsbury's Law on Administrative Courts. Here we go. Halsbury's. Let's have a look. I mean, I wonder if we can actually find it. Halsbury's Law of England and Wales. We actually there should be a link to it. Let's have a look. Making it harder to find. But it basically says there is no authority for administrative courts in this country, and no law can be passed to legitimise them. Is what I was trying to find there. Never mind. The parties were engaged in a preliminary dispute over the characterization of the Bitcoin system, as described in the white paper, where the defendant exchanges were attempting to argue that BSV blockchain had implemented concepts that were not part of the white paper, such as what they called the ability to reverse transactions. Dr. Wright explained in response, this is a technical misunderstanding. The functionality is not a reversal at all, but an additional entry onto the blockchain. Nothing that this is precisely in line with the Bitcoin white paper, which refers to the owner and owners of Bitcoin, not possession. Justice Mellor ultimately decided he was not required to rule on the dispute, but said that he had a strong suspicion that Dr. Wright's technical explanation will turn out to be correct, which will likely come as a shock to anyone still inserting that Dr. Wright obviously knows nothing about Bitcoin. Mellor's complimentary is particularly notable because of all these various judges Dr. Wright has appeared before over the years. Justice Mellor may be the one with the most technical experience. Justice Mellor was a Cambridge-educated engineer before becoming a lawyer later in his career. His specialisation as a barrister was intellectual property, and an area of law central to the passing of cases and more broadly to Dr. Wright's entire legal campaign. Given that Justice Mellor is likely to be the trial judge in the COPA, identity trial, and the passing of cases, that isn't nothing. Well, interesting. You know, it's going to be absolutely huge, but there we go. That's 30 minutes. We'll leave it there. Remember, the largest court case in financial history coming up on the 15th of January 2024. Stay tuned and we'll bring you more. And until then, be aware, take care, stay safe out there, and we'll see you in the next one.